Welcome to Legal Health Nuggets. I'm your host, Dr. Ankur Gupta, and I'm thrilled to have you join us today. As the founder of Negligence, which is an initiative that champions informed consent and transparency through robust feedback systems, and Negligence, which specialize in risk assessments to ensure compliance and patient safety, I'm deeply passionate about the intersection of law and healthcare. So, if you've been listening, then you know that this podcast is about medical legal matters in small nuggets. And in today's episode, we are going to be diving deep into the realm of medical negligence, particularly in Australia, but it applies anywhere in the world really. We will be covering some high-stake cases and some important lessons that they hold for medical specialists, and for any other clinician as well, really. Whether you are a seasoned practitioner or a budding specialist, understanding the legal implications of negligence and how to protect both your patients and your practice is critical. So please tune in for the next 15 minutes as we unpack what medical negligence is, look at some cases, including those in the fast-growing area of cosmetic surgery, and explore the legal and systemic changes that have reshaped patient safety. And we'll also talk about how you can take action to reduce your risk and improve your clinical practice. However, as usual, before we start, a quick disclaimer. The content of this podcast is for educational purposes only and should not be taken as legal advice. The views and opinions shared are based on my experience and research, but for specific legal matters, I encourage you to consult your legal counsel. As always, I want to be transparent about my affiliation with Negligence and MedInspect, both of which inform my perspectives on these topics. Alright, let's jump in now. So, let us start with defining medical negligence. So what exactly is medical negligence? Simply put, medical negligence occurs when a healthcare provider breaches their duty of care, resulting in patient harm. Now, it's important to note that not every adverse outcome qualifies as negligence. So, for a claim to stand, the patient must demonstrate that the healthcare provider's actions or lack thereof deviated from established standards and directly caused harm. So let's break this down using 3 key criteria which must be met to prove negligence. So, criteria 1, duty of care. As a clinician, you owe a duty of care to your patients from the moment you accept them under your care. So that is not difficult for a patient to demonstrate. Number 2, breach of standard of care. So this occurs when the care you provide falls below the accepted standard for a practitioner with your training and experience. So not gold standard, but someone who is at your level of training and experience. And number 3, causation of harm. So the breach of duty must be the direct cause of the patient's harm. And not only that, the harm should have been foreseeable. So these principles stem from what is called the law of torts, where negligence is considered a civil wrong that entitles the harmed party to compensation. Remember, civil wrong, not criminal wrong, although there have been cases of criminal negligence as well, but that is rare and very specific. In general, it is all about a civil wrong that entitles monetary compensation. So all the 3 factors, which is duty of care, breach of standard of care, and causation of harm, must be met before negligence can be proven. So let's move on to some real-world cases that highlight how negligence manifests in different settings. So what I've tried to do in this podcast is to break it down into those 3 principles. So the first case I'm going to talk about is around the principle of duty of care. But this comes from a 1976 case of Tarasov v. Regents of the University of California. So, what happened? Tatiana Tarasov. She was born 1949 in China. Prosenjit Poddar, born West Bengal, India. They were both students at the University of California, Berkeley, and were attending the university in September 67. In the fall of 1968, Prosenjit Poddar met Tatiana or Tanya. They saw each other for about a week until New Year's Eve, when Tanya kissed Prosenjit. Prosenjit interpreted the kiss as a symbol of the seriousness of their relationship. When he explained this to Tanya, she replied that he was wrong and she was more interested in others than him. So Prosenjit suffered emotional distress and he started seeing a psychologist employed on the campus. Tanya went on a vacation to Brazil in September 69 when he told the psychologist that when she returned, he was going to kill her. The psychologist believed that Prosenjit was going to do it, and she notified the campus police requesting that they have him committed to a psychiatric hospital. The police briefly detained him, but he was released because he appeared to be rational and promised to stay away from Tanya. Now, Prosenjit stopped seeing the psychologist after this, and the psychologist raised it with the psychiatrist who happened to be her superior, and the psychiatrist said, well, no further steps needed to be taken, and that there was no need to warn Tanya either. In late October 69, Prosenjit shot Tanya with a pellet gun, then stabbed her repeatedly. She died aged 20 years old. So Tanya's parents brought suit against the psychologist, the psychiatrist, and the campus police, along with the University of California, for failure of duty of care for not warning anyone of the risk. And eventually, they won the case, and this has come to be known as the Terestov principle, wherein clinicians are obligated to breach confidentiality if they believe that there is a significant or material risk to another person. All right. Second, standard of care case. Now, the standard of care is a vexed principle because, as you can well imagine, there can be so much that can be argued for and against. So, in law, they are tested on the basis of two principles, the Bolam principle and the Bolitho principle. And I'm sorry for getting too technical, but it's important. So, the Bolam principle is the older of the two. So, what it states is that a clinician is deemed not to fail the standard of care if a responsible body of similar medical peers support their action. Now, Bolam principle is adopted in Australian jurisdictions, and all states have their version of a Civil Liability Act. However, common law continues to apply in the Australian Capital Territory and the Northern Territory. There is a further qualification to the Bolam standard in New South Wales, South Australia, Tasmania, and Victoria, but not in Queensland, that the relevant peer opinion must be widely accepted in Australia. So, overseas practice becomes inadmissible as a standard of care. So no patient can take you to court and say, well, this is how they do it in America. But, if the standard of practice meets the usual standard in Australia, for instance. However, there is a lot of criticism of the Bolam principle because it has been perceived as being excessively reliant upon medical testimony supporting the defending clinician. So it fails to draw a distinction, if you like, between what is done, what is the done thing, and what ought to be done. So whether an action is negligent or not should be judged against a standard of what ought to be done. That is what the opponents of Bolam principle say. So something which is done, even by most people, would be negligent if it falls below the standard of what ought to be done. That is the premise of the Bolitho principle. And where does it come from? It comes from Patrick Bolitho, 2-year-old child who suffered catastrophic brain damage because of cardiac arrest secondary to respiratory failure. So he was being attended to by a senior pediatric registrar who did not attend the child because she ascribed to a school of thought that medical intervention, intubation in his case, under those particular circumstances would have made no material difference to the end result, and that Patrick Bolitho would have passed away anyways. This view was supported by an impressive and responsible body of medical opinions. Everybody said, well, that's fine, that's a humane thing to do. The parents took the hospital to court, and the courts agreed with the hospital and said, well, even if the registrar had attended to Patrick Bolitho, she would not have done anything that would have materially affected the outcome. However, the case then went to the House of Lords in the UK, which held that a defendant cannot escape liability by saying that the damage would have occurred in any event. So, there was a need to decide if the hypothetical decision not to intubate Patrick Bolitho would have been a breach of duty. So this case would have passed the Bullen test, if you see, because the doctor was supported by expert medical opinion. However, Bolitho shifts the balance from excessive reliance on medical testimony supporting the doctor to a more inquiring approach taken by the court. So, and this played out also in the seminal case of Rogers v. Whittaker from Australia, which is cited all over the world. And I would urge you, my listeners, to please Google Rogers v. Whittaker and read about it. But essentially, in the judgment, His Highness stated that standard is not determined solely or even primarily by reference to the practice followed or supported by a responsible body of opinion in the relevant profession or trade. The principle that while evidence of acceptable medical practice is a useful guide for the courts, it is for the courts to adjudicate on what is appropriate standard of care after giving weight to the paramount consideration that a person is entitled to make his own decisions about his life. So, this implies that in order to reach its own conclusion on the reasonableness of clinical conduct, the court will arbitrate on the standard in each case. I hope that sort of clarifies the distinction between Bullen and Bolitho, but I'll be happy to take questions and comments on the podcast and answer if you had any. Alright, move on. The third case I want to look at is based on the principle of causation. Remember, causation has to be direct and the harm has to be foreseeable. So, the foreseeable factor essentially means that the harm has resulted which would not otherwise have occurred. On the balance probability, for example, the action of the doctor was more than 50% likely to have caused the harm. Claimant's loss is then assessed in terms of quantum, i.e. loss of current and future earnings, reduced quality of life, mental anguish, and the recompense is money, nothing more, nothing less. Remember, it is a civil case. So there was the Vanessa Anderson case, which was about failure in post-operative care. So it is one of the most well-known examples of medical negligence in Australia. 16-year-old Vanessa was admitted to Royal North Shore Hospital in 2005 following a minor head injury. However, a series of preventable mistakes, allegedly, during her care resulted in her tragic death. So, the key failures which were mentioned were improper monitoring after administering pain relief with oxycodone. That led to respiratory failure. There was lack of effective communication between the medical teams. Junior doctors were inadequately supervised. That led to further delays in recognizing her deteriorating condition. The fallout from this and similar other cases led to significant scrutiny of cosmetic surgery in particular, but other fields, and led to regulations. It also highlighted the importance of stringent oversight and the need for mandatory reporting of complications in fields like cosmetic surgery. So the issue we have is that there have been several high-profile negligence cases which have prompted legal and systemic reforms in Australia and many other jurisdictions across the world. And they directly impact the daily practice of clinicians. So, for a very firm example is the very recent stricter regulations for cosmetic surgery, which have been introduced by the APRA in Australia. And, this includes need for better training requirements, clearer reporting systems of complications, and more sort of clearer communication and informed consent for patients. There is also increased accountability for supervision. So Vanessa Anderson's case, for instance, triggered reforms in hospital supervision protocols, particularly ensuring that junior doctors receive adequate oversight in critical care environments. The other thing which has happened because of this is that there has been an implementation around faster response mechanism for patient complaints by regulatory bodies. So medical negligence is something that we all clinicians have to be very clear about. And there are certain things that we can do to minimize our risk. Now, none of them are rocket science. They are very, you can predict them, but I'll lay them out anyways. So, effective communication. So you have to ensure that patients are fully informed about the risks and benefits of any intervention. It could even be medication or, testing. Always document the consent process meticulously, especially for high risk or elective procedures. A word of caution, using generic consent forms can be a problem because they do not cover material risks. And material risk is where people usually fall down with regards to the informed consent. So material risk is a pertinent risk for a particular patient. So something which is very individual, just to keep in mind. Now, and then adherence to clinical guidelines. You have to keep up to date with the latest clinical guidelines, and you have to apply them consistently. Neglecting guidelines can be a red flag. Then realistic expectations. Particularly in cosmetic surgery, managing patient expectations is critical. Honest communication about potential outcomes can help prevent dissatisfaction and legal challenges. Supervision and collaboration is the other thing. So you have to make sure that junior staff are properly trained and supervised, and you have to maintain open communication within the teams. I will also say that if you have nursing staff or other doctors working under your supervision, then you can be held liable for their actions. Continuous learning is the other thing that you have to do. So my CPD home, make sure that your CPD is up to date, because medicine is always evolving, and staying current with new developments and regulatory changes is the key to minimizing risk. Right, that's been a heavy episode, but before we wrap up, I want to leave you with a thought on clinical guidelines. While clinical guidelines are a valuable tool, and they're also increasingly used in litigation, particularly by claimants. So while they can be a defense, they are a double-edged sword. The Bolitho judgment allows court to assess whether a guideline meets the appropriate standard of care, which means guidelines alone may not be enough to protect you, because guidelines do not cover what ought to be done. Anyhow, just with that thought, I thank you for tuning in to this episode of Legal Health Nuggets. I hope the cases and strategies we've discussed today have provided valuable insights for your practice. In our next episode, we will explore the complexities of patient confidentiality and the legal implications surrounding it. Until then, I'm Dr. Ankur Gupta, reminding you to stay vigilant, informed, and always committed to patient safety. Goodbye.